A document so controversial it remained sealed for 83 years exists within South Carolina's probate records. Dated March 1857, the last will and testament of Colonel Augustus Fairmorn distributed his entire estate, valued at what would be millions today, to a single beneficiary. Not to his wife of 26 years, nor to his 3 legitimate children. Not to his brother, who'd fought beside him in the Mexican War. To a woman whose name appeared in his ledgers under a very different category of property went the sole inheritance of Fairmont's 1,400 acres, his Charleston townhouse, his cotton factoring business, and his considerable investments. A legal battle that would consume 3 law firms, divide Charleston society, and expose secrets powerful families spent decades trying to bury was sparked by the reading of that will. Before the story of Augustus Fairmorn and the inheritance that shouldn't have existed continues, make sure you're subscribed to Liturgy of Fear. Hit that notification bell, because stories like this one don't appear in history books. Tell us in the comments what state you are listening from right now. We love knowing where our audience discovers these dark corners of American history. What makes the Fairmorn case so disturbing isn't just the will's revelation, but what it forced into the open about the hidden structures beneath Southern gentility. Everything the antebellum South wanted the world to see was represented by Charleston in the 1850s. Lining the Battery were white columned mansions, their piazzas catching the harbor breeze. The faithful were called to worship on Sunday mornings by church bells from St. Michael's and Street Phillips. Carriages carrying ladies in silk dresses and gentlemen in fine broadcloth rolled down Meeting Street in the afternoons. The city's wealth came from rice, from indigo, from Sea Island cotton, products of the plantations that sprawled across the low country like kingdoms unto themselves. Along the Ashley River, 30 miles inland, sat Augustus Fairmont's plantation, Riverside. In the Georgian style, symmetrical and imposing, the main house, built in 1789 by his grandfather, rose 3 stories, its design declaring permanence. An alley from the river road to the front portico was formed by live oaks older than the nation itself. Stretching behind the house were the working buildings, the kitchen house, the carriage house, the overseer's cottage. And further back, beyond a stand of pines, lay the quarters where nearly 200 people lived under conditions the law recognized as property ownership. An impressive figure in Charleston society was cut by Fairmorn himself. In 1857, he was 47 years old, standing over 6 feet tall with the bearing of a military man, which he had been during the Mexican War. A commendation and a bullet still lodged near his spine, which gave him a slight limp in damp weather, were what he'd returned with. He served on the vestry of St. Philip's. To the South Carolina Society, the Hibernian Society, and the Agricultural Society, he belonged. Weight on Broad Street was carried by his opinions on cotton futures. When he spoke at public meetings about states' rights and Southern sovereignty, people listened. From the Rutledge family, old Charleston aristocracy with connections that mattered, came his wife, Margaret Louisa Fairmorn. A substantial dowry had been brought to the marriage in 1831, 30 enslaved people, $10,000 in railroad stock, and the kind of family name that opened doors. 3 children who survived infancy were born to Augustus: Catherine, born in 1832, Augustus Jr., born in 1835, and Margaret, called Meg, born in 1838. The ideal Southern family, prosperous, respectable, devout, was what they represented by all appearances. But carefully constructed performances were what appearances in Charleston society were, and with particular rigidity, the Fairmorn household maintained its performance. Under the direction of a woman named Celia Russo, the household staff at both the plantation and the Charleston townhouse operated. In 1857, she was 28 years old, unusually light-skinned and literate, a dangerous combination of attributes that would have raised immediate questions in any other household. Her purchase in 1843 from a Savannah estate sale for the extraordinary sum of $1,500, triple the typical price, with no explanation for the premium, was listed in Fairmont's ledgers. Celia held no official title, yet she controlled access to Fairmorn, managed his correspondence, and occupied a small room in the main house at Riverside rather than in the quarters. Plain but quality fabrics were what she dressed in. A gold locket that no one had ever seen her without was what she wore. The diction of someone educated beyond her supposed station was how she spoke, and with an authority that made visitors uncomfortable and made Margaret Fairmont's lips thin with barely suppressed rage, she moved through the Fairmont house. About these arrangements, plantation society had its unspoken rules. Often, men of means maintained relationships that existed in the shadows, producing children whose parentage everyone knew but no one acknowledged. As long as certain proprieties were observed, as long as the legal wife maintained her position, as long as the children of these unions remained enslaved, as long as the whole structure stayed buried beneath genteel denial, society could function. Every single one of those rules had been violated by Augustus Fairmont, though no one yet understood how completely. To the Low Country in the spring of 1857 came an unusual drought. Cracked and dry stood the rice fields that should have been flooded. The slow decline that would accelerate into the Panic of '57 by August had been begun by cotton prices. To Northern aggression, to the Dred Scott decision handed down that March, to whether the Union could survive, conversation turned more frequently in Charleston's drawing rooms. With more than humidity, the air felt heavy. The weight of a world beginning to crack at its foundations was what it carried. A more personal form was taken by the tension at Riverside. To Charleston in February had returned Margaret Fairmont, taking young Meg with her, and she had not come back to the plantation. In the city as well remained Catherine, now 25 and unmarried, a source of growing concern. Only Augustus Jr., training in his father's cotton factoring business, made occasional visits to Riverside, and even he found reasons to keep them brief. Primarily of Augustus, Celia, the field workers, and the immediate house staff consisted the household at Riverside then. During this period of relative isolation began Augustus Fairmont the arrangements that would shatter everything his family assumed about their future. On the evening of March 14, 1857, word was sent by Augustus Fairmont to Charleston requesting the presence of his attorney, Josiah Prescott, at Riverside. That Prescott should come alone and should bring the necessary materials for drafting a complex testamentary document was specified by the message, delivered by a trusted courier. The request was found unusual but not alarming by Prescott, who had served the Fairmont family for 15 years. Often, wealthy men updated their wills. The scene he encountered in Fairmont's study 2 days later was what he did not expect. That he arrived at Riverside on the afternoon of March 16 to find Fairmont in obvious physical distress would later be testified by Prescott in court. Behind his mahogany desk sat the colonel, his face drawn and grey, one hand pressed against his lower back. At his elbow sat a decanter of whiskey, unusual for a man who typically drank with moderation. Celia's presence in the room was most striking, not serving, not waiting for instructions, but seated in the leather chair normally reserved for business associates, her hands folded in her lap, her expression composed. "Sir, I should perhaps call for Dr. Middleton," Prescott said, noting the sheen of sweat on Fairmont's forehead despite the cool March weather. "No doctors," came Fairmont's voice, rough but firm. "Exactly what's wrong with me I know, Josiah, and no physician can cure it. A will tonight I need you to write, and I need it done exactly as I dictate, no matter what your professional judgment might counsel." At Celia, whose presence made the situation deeply irregular, Prescott glanced. "Colonel, these matters are typically, I need witnesses who can read and write and who will testify to my soundness of mind," Fairmont interrupted. "One of the most intelligent people I know is Celia. She'll witness. 2 others among my people who can sign their names you'll find. I've already arranged it." Palpable was the attorney's discomfort, but a client of significant standing was Fairmont. His case was opened and his materials prepared by Prescott. A dictation that would take nearly 3 hours, interrupted frequently by Fairmont's pauses to master what was clearly considerable pain, was what followed. Conventionally enough began the will, with the standard declarations of soundness of mind and body, though the latter was clearly generous, and the revocation of all previous testaments. Then came the provisions that would change everything. To Celia Rousseau, Fairmont dictated, his words precise despite his physical suffering, currently held as property at Riverside Plantation, "I give and bequeath her immediate and unconditional freedom upon my death, along with all documents necessary to establish her status as a free woman of color under the laws of South Carolina and the United States." Hesitated Prescott's pen. Uncommon in wills were manumission clauses, though they were becoming increasingly restricted by state law. But just beginning was Fairmorn. To the aforementioned Celia Russo, now to be known as Celia Russo Fairmorn, I further give and bequeath the entirety of Riverside Plantation, including all lands, buildings, equipment, livestock, and all persons currently held in bondage thereon. To her I further bequeath my townhouse at number 14, Trad Street in Charleston, along with all furnishings and household goods therein. Stopped entirely the scratching of the pen. Colonel, I must strongly advise, began Josiah. An edge that silenced objection was carried by Fairmont's voice. To Celia Russo Fairmorn I further bequeath all shares and interests in the firm of Fairmorn and Lazarus Cotton Factors, all railroad stock, all bank deposits, all bonds and securities, and all personal property of every kind and description. Sole executrix of this my last will and testament I appoint her, with full power to act without bond or judicial oversight. Except for the sounds of Prescott's pen and the distant evening songs from the quarters, the room had grown very quiet. Perfectly still sat Celia, her face revealing nothing. Regarding my wife, Margaret Louisa Fairmorn, Augustus continued, each word seeming to cost him, the legal minimum dower right required under South Carolina law I hereby grant her 1/3 of my real property for her natural life. However, subject to Celia Russo Fairmont's primary ownership and management shall be said dower right, and no voice in the administration of any property whatsoever shall Margaret Louisa Fairmorn have. Even pretending to write had stopped Prescott. Colonel, your wife has legal protections. Your children have expectations. In court, this will not stand. Beyond the legal impossibilities a woman of color cannot own. Write it all down, Josiah. Exactly as I say it. Ways around the legal restrictions there are, and you know it. In trust, property can be held. Arrangements can be made. The law I've studied. He stopped, his breathing labored. Write that I acknowledge Celia's son, Daniel, born June 12, 1844, as my natural child, and I direct that he be raised as a free man with all advantages available to him. The air in the study seemed to thicken with the silence that followed this statement. In 1857, Daniel was 13 years old, a boy who worked in the Riverside stables and who bore such a resemblance to Augustus Fairmorn that only willful blindness could deny the connection. Explicit was made what society demanded remain forever unspoken by the acknowledgement in writing. Furthermore, Augustus said, his voice weakening, I acknowledge Celia's daughter, Ruth, born April 3, 1847, as my natural child, and I direct that she be raised with the same advantages. 2 children, not merely one indiscretion, but an ongoing relationship spanning at least 13 years, producing offspring who shared blood with the legitimate Fairmorn heirs but who had lived their entire lives in legal bondage to their own father. His voice was found by Prescott. Colonel, in good conscience I cannot allow you to proceed without understanding the consequences. Immediately, your wife will contest this. Your children will never accept it. Charleston society will. Charleston society, Augustus interrupted with unexpected venom, on systematic rape built its fortune and called it breeding stock. Children whose fathers own them are contained in every fine house on the Battery. The very people he claims as property are violated by every respectable gentleman by night after conducting business by day. The only difference, Josiah, is that the truth about it I am telling. In legal writing I am putting what every man in Charleston does in the darkness. He leaned forward, and the movement clearly cost him. Dying I am, Josiah. That the cancer spreading from my bowels would kill me within the year was told to me by Dr. Middleton 6 months ago. From everyone except Celia I've hidden it. Possibly less, perhaps weeks remaining I have. And I cannot leave this earth knowing that my own children will be sold to settle my debts, or that the woman I should have had the courage to marry openly will be returned to bondage when I die. Like smoke hung the admission in the air. Slightly trembled Prescott's hands as he resumed writing. For the next 2 hours, they worked through the technical details, the trust arrangements that might survive legal challenge, the specific bequests designed to provide immediate liquid assets, the careful wording that attempted to thread the needle of South Carolina law regarding property rights and manumission. When the document was finally complete, insisted on reading it through himself did Fairmorn, his finger following each line despite the obvious pain the focus caused him. Then with a steady hand he signed it, the signature no different from the one he'd used on hundreds of business documents. As witness signed Celia, her handwriting notably educated and precise. 2 other enslaved people from the plantation, a man named Samuel, who served as a blacksmith and had taught himself to read, and a woman named Hannah, who'd learned letters from a former mistress, were brought in to witness as well. With evident discomfort, Prescott noted their marks and signatures. "With my other documents I'll file this," carefully said Prescott as he prepared to leave. "But, Colonel, I urge you to reconsider. At least more substantially for your legitimate children provide some gesture that might soften their response make." "My legitimate children," Augustus said, and infinite weariness was in his voice, "will inherit the protection of their mother's family name, the education I've already paid for, and the social position that comes with white skin in Charleston. Nothing but their freedom will Daniel and Ruth inherit if I don't act now. As things the law sees them, Josiah. Things I own, things that could be sold to pay my creditors if I don't make this ironclad." At Celia then he looked, and something passed between them that Prescott could not name. "A coward's life I've lived. Let me at least die honestly." That evening, Prescott departed Riverside with a document he knew would destroy multiple lives, possibly including his own professional reputation. Through darkness he rode back to Charleston, turning over in his mind whether a legal obligation to inform Margaret Fairmorn of what her husband had done he had. That attorney-client privilege prevented him from speaking, he decided, perhaps out of cowardice himself. His silence would be what allowed the situation to unfold as catastrophically as it did. Another 6 weeks lived Augustus Fairmorn. During that time, at Riverside he remained, his condition deteriorating rapidly. Through increasing pain Celia nursed him, administering laudanum when it became unbearable, reading to him in the evenings from books they'd apparently shared for years, history, philosophy, poetry. Openly during his final days were Daniel and Ruth allowed to visit their father, a sight that scandalized the white overseers but that none of them dared question, given Fairmont's fearsome reputation even in decline. Did not visit Margaret Fairmorn. Whether she'd heard rumors of her husband's condition and chose to stay away, or whether Augustus had deliberately prevented word from reaching her, the historical record does not make clear. But in Charleston she remained, attending social functions, maintaining the fiction that her husband was simply occupied with plantation business during the difficult agricultural season. On the morning of April 28, 1857, died Augustus Fairmorn. With him at the end was Celia. According to later testimony from the house staff, his last words were, "Tell them the truth. All of it." More destructive than even he might have anticipated would the truth prove when it emerged. The same day reached Charleston the news of Colonel Fairmont's death. By protocol and custom, visitors offering condolences were received by Margaret at the Tradstreet house. Black silk she wore, received guests in the parlor, accepted their expressions of sympathy with appropriate dignity. On her composure, on the strength she displayed in her time of trial, everyone remarked. That she'd already lost everything she had no idea. For May 3 was scheduled the reading of the will, 5 days after Augustus's death, and 1 day after his burial in St. Philip's Churchyard, a burial that Margaret had insisted be properly conducted despite her private fury at her husband's long absence and sudden death. Only family and close associates had she invited to the reading: her brother, James Rutledge, her children, Augustus's brother, William, and several family friends who'd served as informal advisors over the years. At 10 o'clock in the morning, Josiah Prescott arrived at the Tradstreet house, carrying the will and wearing the expression of a man walking to his own execution. Twice he'd tried to meet privately with Margaret before this moment to prepare her, but she'd been too occupied with funeral arrangements to see him. Now in public before witnesses, he would have to deliver the news. In the largest chair in the drawing room sat Margaret, her children around her. At 25, Catherine had never married despite her mother's efforts, a source of ongoing tension that had deepened when Augustus refused to provide an adequate dowry for the matches Margaret had arranged. Augustus Jr., 22, worked in his father's cotton factoring business and assumed he would inherit both the firm and the plantation. With her hands folded sat young Meg, 19, still the beautiful daughter of furniture polish and the flowers that had been arriving steadily since the news of Augustus's death smelled the room. Through the tall windows overlooking the garden streamed spring sunlight. Civilized, ordered, Proper appeared everything. Cleared his throat Prescott. Mrs. Fairmorn, family members, I must begin by saying that highly unusual are the contents of Colonel Fairmont's last will and testament. Against several provisions I advised, but adamant was the Colonel, and in my professional judgment of sound mind when he dictated his wishes. Unnecessary suggested this preamble Margaret's expression. Particular about his affairs my husband was always, Mr. Prescott. Please proceed with the reading. For the rest of their lives would be remembered by everyone present what followed. Quickly Prescott read through the opening sections, the standard legal language, the revocation of previous wills. Then the substantive bequests he reached. Strained became his voice as he read the words that granted freedom to Celia, that acknowledged Daniel and Ruth as Augustus's natural children, that transferred the entirety of the estate to a woman who had been legally property when the will was written. Immediate was not the reaction. For several seconds, the room remained silent as the assembled family tried to process what they had just heard. Confused looked Catherine as if she'd misheard. Forward leaned Augustus Jr., his face reddening. The arms of his chair gripped James Rutledge. Absolutely still went Margaret Fairmorn. Then exploded Augustus Jr. This is absurd. Forgery it is. My father would never, he couldn't have. To me directly your father dictated this will, quietly said Prescott. His signature I witnessed. Properly executed has the document with multiple witnesses. Witnesses, cut through the chaos James Rutledge's voice. What witnesses? Who would witness such a document? When Prescott explained that the witnesses included enslaved people who could read and write, including Celia herself, erupted the room. At once spoke multiple people. Stood and paced Augustus Jr., his hands clenched. Began to cry Catherine. But seated and silent remained Margaret, her face hardening into an expression that suggested not shock, but confirmation of long-held suspicions. Finally, one hand she raised, and the room quieted. When she spoke, the cold precision of sharpened steel was carried by her voice. How long? Prescott blinked. I'm sorry, Mrs. Fairmorn. How long was my husband conducting this relationship with his property? Hesitated the attorney. Children born in 1844 and 1847 the will acknowledges. 13 years, softly said Margaret. In 1838 was my youngest daughter born. For 19 years of our marriage. Then, while I bore his children, managed his household, maintained his position in society, she stopped, mastering herself with visible effort. And this woman, this Celia, my home she now owns. Your dower right provides for you 1/3 of the real property for your lifetime. Subject to her ownership. Under her management. The house she owns. The plantation I furnished. The business I helped build. My dowry helped establish, to barely above a whisper had dropped Margaret's voice, which somehow made it more terrible than shouting would have been. And nothing inherit my children? That would soften the blow. Prescott had no answer. By the provisions of Augustus Fairmont's will, no direct bequests received his legitimate children. To the plantation, the Charleston properties, the business interests, or even their father's personal effects they had no claim. To Celia and her children everything had been transferred. Found his voice Augustus Jr. Slavery's revenge this is. Mad my father went. Some disease of the mind he must have had. Your father was in full possession of his faculties, firmly said Prescott. Exactly what he was doing he understood. Explicitly he stated that an injustice he was correcting. Injustice, rose Catherine's voice. Beggars has made us. Nothing we have. With no portion, how am I to marry? In business, how is Augustus to establish himself? To live, how is mother? The dower right provides. The dower right provides for us to live as dependents in our own home at the pleasure of a woman who was property, stood now James Rutledge, his voice shaking with rage. Unconscionable this is. Illegal it is. In South Carolina, beyond the most limited, a woman of color cannot own property. In trust the property is held, with arrangements I believe will withstand legal challenge, said Prescott. Extensively the law Colonel Fairmorn studied before drafting these provisions. Stood then Margaret, and something in her posture made everyone else fall silent. Where is she now? Mrs. Fairmorn? Where is the woman who has taken my life? Visible was Prescott's reluctance. At Riverside with the children she remains, as the will specifies is her right. Her right, tested the words Margaret like poison. Send word to her. Tell her that the family wishes to discuss the terms of the will. Tell her we may be prepared to reach an accommodation that would avoid the ugliness of a public contest. Tell her, she paused, and terrible was her smile. Tell her I wish to meet my husband's other family. That afternoon went the message to Riverside. The next morning arrived Celia's response. To Charleston she would come, but only with legal representation present. At Prescott's office rather than the Trad Street house she suggested they meet, and she insisted that Daniel and Ruth would accompany her, as they had as much right to hear the discussion as Augustus's legitimate children. For May 8 was scheduled the proposed meeting. In the 5 days between Margaret's discovery of the will and that meeting, with scandal caught fire Charleston society. The details leaked, perhaps through household servants, perhaps through deliberate whispers from Margaret's allies, perhaps simply because secrets of this magnitude could never be contained. By the end of the first week of May, everyone in Charleston's upper circles knew that Colonel Augustus Fairmorn had freed his enslaved mistress in his will, had acknowledged their children, and had disinherited his white family to provide for them. Along predictable lines split the reactions. On Margaret's behalf, outrage was expressed by many, calling Augustus's actions a betrayal of everything civilized society held dear. How could a man of his standing, his reputation, his position, commit such an act? That Augustus had only made public what half of Charleston practiced in private was whispered by others, particularly among the younger men. That perhaps there was something admirable in a man trying to provide for children he'd fathered, regardless of their mother's race, was dared to be suggested by a few, very few. But beneath all the public discourse ran a deeper current of fear. If Augustus Fairmorn, respected, wealthy, connected, could do this, what did it say about the stability of other arrangements? How many other white families might find themselves displaced by the very people they'd kept in bondage? A fundamental violation of the unspoken rules that allowed Southern society to function was what the will represented. Challenged it had to be, defeated it had to be, or like cholera through the social order would the implications spread. On May 8 took place the meeting in Josiah Prescott's office on Broad Street, in a room far too small for the number of people who crowded into it. First arrived Margaret with her brother James, her children, and 2 additional attorneys she'd retained, specialists in probate law from prominent Charleston families. On one side of the long table that dominated the room they arranged themselves. When Celia arrived, immediate and visceral was the effect on the room. A dress of dark grey wool, simple but well made, with a white collar, was what she wore. Severely was her hair pulled back. Remarkable composure for a woman walking into a room full of people who wished her destroyed was how she carried herself. A suit that had clearly been tailored for him, not servant's clothes, but the kind of outfit a gentleman's son would wear was what Daniel, at 13, wore. A blue dress with careful stitches, her hair in neat braids, was what Ruth, at 10, wore. The unmistakable Fairmorn features were borne by both children, Daniel especially, with Augustus's strong jaw and deep-set eyes. When Margaret Fairmorn and Celia Rousseau faced each other across that table, more unspoken history than any document could capture was contained in the moment. For 14 years, these 2 women had lived in the same houses, one as mistress, one as property. Augustus Fairmont's children had been born by both of them. Around a man who'd kept them in separate worlds that should never have intersected, they had both, in different ways, built their lives. Now collided had those worlds, and in the wreckage would one of them be destroyed. First spoke Margaret, her voice controlled but carrying an edge like ice cracking. You understand, I presume, that my husband's will cannot stand. That the law protects a wife's rights. That no court in South Carolina will allow this travesty. Directly met her gaze Celia, a deliberate violation of the social codes that governed how a woman of color should address a white woman, especially one of Margaret's standing. I understand that your husband chose to acknowledge the truth. Finally. Like a physical blow landed the simple statement. Slightly cracked Margaret's composure, color rising in her cheeks. You seduced him. Used your position in his household to manipulate a man who, 14 years old I was when your husband purchased me in Savannah. Level remained Celia's voice but gained intensity. 14. I didn't seduce anyone, Mrs. Fairmorn. By my previous mistress I was taught to read and write, which made me valuable as a household manager. That's what your husband told people. For the truth about what else I was purchased for, he bought me. What I had no choice about. I assume you can imagine. Deathly silent had gone the room. Half rose from his chair Augustus Jr., but James Rutledge gripped his arm, holding him back. You will not speak to my mother that way, shaking, said Catherine's voice. You have no right to. Every right I have, turned to Catherine Celia, and now steel was in her tone. The right your father gave me in his will I have. The right of someone who managed your household, raised your children when they were young, kept your father's books, ran his business affairs when he was away, and bore his children just as your mother did, I have. The only difference is that without choice, without legal protection, without the ability to say no, I did all of it. And now what he should have given me 13 years ago, my freedom and the means to protect my children, your father has tried to give me. Interjected Margaret's attorney, a grey-haired man named Bogard Simmons. Miss Russo, your personal history, however unfortunate, is not relevant to the legal questions at hand. Multiple provisions of South Carolina law are violated by Colonel Fairmont's will. In this manner to a woman of color, property cannot be transferred. Of an enslaved mother, children born are themselves enslaved and cannot inherit. Any testamentary provisions to the contrary are superseded by the dower rights of the legal wife. On multiple grounds, legally invalid is this will. Then why are we having this meeting? Asked Celia. If so confident you are the will is invalid, why not simply proceed to court? A glance was exchanged by Simmons and James Rutledge. More complicated than Celia's question suggested was the truth, and everyone in the room knew it. A patchwork of contradictions was the legal landscape regarding property rights and race in 1857 South Carolina. While the law severely restricted what free people of color could own or inherit, it also recognized trusts, recognized private arrangements, and critically recognized that white men of property had certain privileges in disposing of their estates. Carefully had Augustus structured the will, using legal mechanisms designed to survive challenge. More importantly, details that neither family wanted examined would be exposed by a public court battle. Cleared his throat James Rutledge. We are here, Miss Russo, because despite the legal invalidity of this document, we recognize that unpleasant for all involved would be a protracted court case. Public record would become the details of my brother-in-law's private life. Named would be names. Scrutinized would be children. A settlement that would provide for you and your children's future without the necessity of litigation we are prepared to offer you. How generous, said Celia, and barely veiled was the sarcasm. What are the terms of this settlement? Leaned forward Margaret. Your freedom you receive, which the law would likely grant regardless. $20,000 you receive, enough to establish yourself and your children comfortably anywhere in the North, where toward your situation attitudes might be more accommodating. In exchange, any claim to the Fairmorn properties, the business interests, you renounce, and within 30 days you leave South Carolina. Substantial in monetary terms was the offer. $20,000 represented significant wealth. But a fraction of what the estate was worth it was, and everyone in the room knew it. More importantly, it required Celia to abandon the South, to take her children away from the only home they'd known, to accept exile as the price of their freedom. Everything your husband left me because he knew what would happen to me and my children if he didn't, quietly said Celia. He knew that the moment he died, vulnerable I would become, that someone would try to sell me to settle debts, or that your family would try to remove me. He knew that Daniel and Ruth, his children, would be treated as property to be disposed of. 6 weeks dying in agony your husband spent, Mrs. Fairmorn, and to ensure we would be protected he used that time. I don't believe he would want me to accept 30 pieces of silver and disappear. How dare you quote scripture at me? To a hiss dropped Margaret's voice. You who helped destroy my marriage, who lived in my houses, who to my husband bore children while she stopped, visibly fighting for control. Mother, please, placed a hand on her mother's arm Catherine. But off shook her Margaret. No. For too long silent I have been. For too long accommodating. The gracious lady playing while under my own roof happened my husband's infidelity. To Celia she turned her full attention, and beneath the anger suddenly visible was the pain. Did you love him? The air hung the question, transforming the legal negotiation into something more raw and human. Slightly finally cracked Celia's composure. 14 I was when he bought me, Mrs. Fairmorn. To survive I learned. Whether that became love or simply the need to protect myself and my children, I don't know if I can answer that question. But I do know that the only gift he gave me, the chance to not be property anymore. And I know that if I surrender that now, their lives my children will spend vulnerable to anyone who decides their freedom is inconvenient. Throughout the exchange silent had remained Josiah Prescott, finally spoke. Perhaps on the children we might focus. Surely that the welfare of these young people, all of them, should be paramount, can agree both families. My children's welfare, coldly said Margaret, by this will is threatened. Without capital, in business my son cannot establish himself. Without portions, appropriate marriages my daughters cannot make. Enslaved born were this woman's children and under the law should remain so. Throughout the meeting silent had been Daniel, finally spoke. Young but steady was his voice. 13 years old I am. For my entire life, property I have been. My mother serve people who owned her I have watched. Alongside men who could be sold at any moment, in stables I have worked. A 10-year-old sister I have who knows that her life could be bought and sold. My father he was, everyone can see it, everyone has always known it, what you take for granted tried to give us my father, the right to own ourselves. How is it justice to take that away? A moment of uncomfortable silence was created by the directness of the statement coming from a child who'd had no voice in any of this. At Daniel looking, perhaps seeing for the first time a half-brother rather than property, seemed about to speak Augustus Jr., but his mother's glare silenced him. Justice, said Margaret, by destroying one family to benefit another is not served. Mr. Simmons, how do we proceed with the legal challenge? The strategy was outlined by Simmons. For probate in the Court of Common Pleas they would file, arguing that public policy was violated by the will, exceeded the testator's legal authority to dispose of property to persons of color, and infringed upon Margaret's dower rights. To testify to Augustus's erratic behavior in his final weeks, suggesting diminished capacity, they would call witnesses. That Celia had exercised undue influence over a dying man they would argue. As Simmons spoke, notes was made by Celia's attorney, a man named Thomas Grimball, one of the few Charleston lawyers willing to take such a controversial case. On religious grounds Quaker was Grimball, opposed to slavery, and willing to weather social ostracism to challenge it legally wherever possible. Precisely that opportunity gave him the Fairmorn case. With no agreement concluded the meeting. To court would move the battle, and what that meant was understood by everyone present. Months or years of litigation, astronomical legal costs, and the inevitability that questions it preferred to leave unasked would be forced to examine Charleston society. As they filed out of Prescott's office, within inches of each other at the door passed Margaret and Celia. Paused Margaret, turned, and so softly that only Celia could hear, spoke. When he was dying, your name he called, didn't he? Not mine. Not his children's. Yours. Her eyes met Celia. Yes. For just an instant crumpled Margaret's face before she mastered herself and walked away, her children and attorneys trailing behind her. The last time the two women would speak directly to each other it was. For the next 18 months would consume Charleston society the legal battle that followed, and far more than anyone anticipated would it expose. On May 15, 1857, entered the Court of Common Pleas the case of Fairmorn versus Fairmorn Estate. Judge Hamilton Pinckney, a distinguished jurist with 30 years on the bench and extensive ties to Charleston's planter class, would preside. Which way the wind would blow was suggested by his initial ruling on the preliminary motion. Broad latitude in questioning the will's validity he granted Margaret's attorneys, while restricting Grimball's ability to introduce evidence about Augustus's reasoning or intent. But critical in ways no one initially understood proved the case's timing. That August struck the panic of 1857, triggered by the failure of the Ohio Life Insurance and Trust Company. Across the country, failed banks, dried up credit, already declining, plummeted cotton prices. By September, bankrupt were businesses that seemed solid in May. Hard hit the financial crisis Charleston, and catastrophically hit it the Fairmorn business interests. Leveraged had been Augustus, not excessively by the standards of the time, but enough that immediate problems were created by the sudden credit contraction. Credit to numerous planters against their expected fall crops had been extended by Fairmorn and Lazarus, the cotton factoring firm. When collapsed cotton prices couldn't pay their debts, those planters, which meant couldn't pay its creditors Fairmorn and Lazarus, with Charleston banks were called in the firm's lines of credit. Virtually overnight lost 80% of their value, the railroad stock that had seemed like solid assets. By October 1857, the real possibility of foreclosure faced Riverside Plantation. Had liens against it, the Charleston townhouse. Worthless would be even Margaret's dower rights if to satisfy creditors the properties were sold, and under Augustus's will,